So, welcome back, sir. In the last class, we have done with the discharge of a contract revision. So, we'll do the scanner on the discharge, which contains MTPs, RTPs, and previous exam questions also. So, this was asked in the exam August 2024 model test paper series 2 for 4 marks. Let us read once. Mr. Gaurav and Vikas entered into a contract on 1st July. 1st July 24. Contract is entered according to which Gaurav had to supply 100 tons of the sugar to Vikas. Gaurav has to supply the sugar to Vikas at a certain price strictly within 10 days. When the contract is entered 1st July, we should supply by the 10th July 24. Strictly mandatory. Mr. Vikas also paid the Vikas also paid an amount of 70k towards the advance as per the above contract. He paid the 70,000 advance also. Yes sir, no sir. The mode of transportation available between their places is roadway only. Between Gaurav city and Vikas city, only one road is there, beta. Roadway only. Severe floods came on 2nd July. Floods came on 2nd July. Only road connecting their places was damaged and could not be repaired within next 15 days. That means around 16 July 24. Till that date, we can't repair the road. There is only one road between these two cities where Gaurav is residing, where Vikas is residing. After entering into contract, we are unable to reach that city. Supervening impossibility. Void contract. Subsequent impossibility. Mr. Gaurav offered to supply sugar on 20th. Gaurav said, sorry Vikas, I can't come to your city because there is no road. If you want, I will supply to the 20th because road may be ready by 16th. I will supply it on the 20th. 20th, for which Vikas did not agree. Vikas said, no, I want it by the 10th only because I said earlier, strictly. On 1st August 2024, Mr. Gaurav claimed compensation of 20k from Vikas for refusing to accept the supply sugar. Can Gaurav file a case on the Vikas to get the 20k damages? No. Vikas said, I want by 10th. He's asking by 10th only. Then, which was not within the purview of the contract. So Gaurav cannot claim. Gaurav cannot claim this 20k. On other hand, Mr. Vikas claimed the refund of 70. So how much he gave beta Vikas? 70. Can he get back his 70k? Yes. Subsequently, if the contract becomes void, there is applicability of the principle of restitution, return of benefit. Parties has to restore the benefits they have received. So how much Vikas gave to Gaurav? 70. Whether he is supplying the sugar? No. So we should refund the 70k. So Vikas claiming 70k. Can he claim? Yes. Which he has paid as advance in terms of contract. Unless the above situation, in terms of provisions of Indian Contract Act, is asking as per the provisions of Indian Contract Act. Is asking the asking you to read step number 1, provision of the law. What we should read in provision of the law? Supervening impossibility, subsequent impossibility, void contract, and advise Vikas the contention. Can Vikas get back his 70k? Yes, that is the answer, beta. So we are writing what is the meaning of the void contract, and restore the benefit. If the contract becomes void, parties has to restore the benefits they have received. Here Vikas is correct. This question came for 4 marks, beta. 24 में आया beta. X and Y entered into a contract on 1st August 18, by which X had to supply 50 tons of the sugar to Y, strictly within the 10 days. Same question, beta. In the place of the Gaurav and Vikas, they become X and Y. This question came in 18 and 24, same question. Done. Same 4 marks. X and Y entered into agreement. Same question beta. ये वो क्वेश्चन 21 में आया, 18 में आया, 24 में भी आया, सेम है ना बेटा. 18, 21 सेम क्वेश्चन. 18 and 24 रिपीट हो रहा नहीं हो रहा. नेक्स्ट, मिस्टर जूत entered into agreement with Mr. Such है ना अरे, Such to purchase his motor car for 5 lakhs within a period of 3 months. To purchase his here J is entering into agreement with S. S is the seller, J is the buyer. So J entered into agreement with S to purchase S motor car for 5 lakhs within a period of the 3 months. Within how many months beta? 3 months. S has to give the car within 3 months and J has to take the car within 3 months. A security amount of the 20,000 was also paid by J to H. He paid 20k security amount also. Any beta? Next, after completion of 3 months, after completion of the 3 months of entering in, but within how many months we should buy and sell this? 3 months. After completion of 3 months of entering into agreement, Mr. S tried to contact J to purchase the car in terms of the agreement. So he is making calls every day. Babu, give the 5 lakhs, take the car, give the 5 lakhs, take the car. And beta, S is trying to contact the J. Mr. S tried to contact J to purchase the car as per the agreement. Even after lapse of the another 3 months, 6 months हो गया, Mr. J neither responded to S nor phone calls. So this guy is not taking the car. Done na beta. Beta, whether this 20k is advance money? No, security. Pakka I will take बोल के. That is not advance money. That is security amount. Security अलग होता है, advance अलग होता है. Done beta. Advance towards the price of the good. Security is for the performance. Pakka I will take. I made promise. Not oral promise. Monetary promise को बोलते हैं security. Security will not be refunded. Advance will be refunded. Done. So, after lapse of another 6 months. 1 साल हो गया बेटा. 3 plus 3 6 plus 6. After lapse of 1 year, Mr. J contacted S and denied to purchase the motor car. After 1 year, he is meeting the S. He made a call to S. Yes, I don't want your car. ऐसा कैसा होता है बेटा? After lapse of another 6 months, J contacted S and denied to purchase the motor car. He also demanded back the security amount of 20k from S. Can J demand the 20k back? No. Can he demand 20k? Referring to provisions of the Indian Contract Act, state whether yes is required to refund the security amount. Answer is not a complete question. Still it's there. 4 or 6 marks. I forgot to add the year here. Also exam question number 2. This is question number A beta. In the same question, also examine the validity of the claim made by the J if the motor car would have destroyed by the accident. Car जल गया, then can we ask back subsequent impossibility? है ना? Car is not there. Whether we have to refund the money at that time? Yes. So if motor car would have been destroyed by an accident within the 3 months, within the first 3 months, in this period, so J can demand back the 3 that whatever the security amount paid. Then this is A answer, this is B answer. So Mr. Such is Mr. S can resign the contract, retain the security amount. Here second case law, he has to refund it back. Done. Clear na beta? Next question beta. 4 marks around. All these are the recent questions beta. 2024, 2025 MTPs, RTPs. What will be the rights of the promisor in the following cases? Explain along with reasons. Mr. X promised to bring back Mr. Y life again, dead body को life दे सकते हैं बेटा, void agreement ab initio. Next, X agreed to sell 50 kgs of the apple to B. A is selling the apples to B. The loaded truck left for delivery on 15th, but due to roids in between reached on the 19th. But apple perishable good, perishable good. Apple may perish. The contract may become void contract. अब इसनो कैसे होता है बेटा, बाद में खराब हो गया, ऐसा नो सर. देखो, time is essential, contract will be discharged for delivery of the apples. Food we discussed now yesterday, food etc. curd, milk. An artist promised to paint on the fixed date for the fixed amount of remuneration and met with the accident, lost the both the hands. Painter we discussed yesterday. Void contract agreement, contract subsequent impossibility. After entering into contract, painter lost his hands. Abhishek entered into a contract for import of toys from China. Due to disturbance in relation of both the countries, imports from China is banned. Void, just now we discussed no beta, supervening impossibility, third heading, declaration of the war, Ching Chong Cho of China. MTP series 1 July 24. Which one? Where here we have to refund. Where generally if the contract becomes void, valid contract becomes a void contract, we have to refund the advances. इसको बोलते हैं restitution. We discussed in the coercion, undue influence also. Previous case why we are not refunding beta, or default है beta. That is not general void contract. You are making a default. Then beta, situation is different there and here. Next, how is a contract is discharged under the Indian Contract Act? How is the contract is discharged under the Indian Contract Act? What are the different ways? 6 ways. First one by performance, second one by mutual agreement, third one operation of law or impossible operation of law. Next, impossibility of the performance. Next, lapse of time. Next, operation of, next, breach of contract. He's giving some 2-3 extra. Promise may be waiver. Waiver is part of the mutual consent only. Yes sir, no sir. Explain the any 5 circumstances under which contract need not be performed with the consent of both the parties. Exception, the various ways of the discharge of a contract by mutual consent. Novation, rescission, alteration, remission and waiver. Then date question. I said no. Date question आता बोल के. Next, what are the instances for discharge of a contract by mutual consent? Same question. Third time 1, 2, 3 above 2 times. है ना? Novation, alteration, remission, rescission, waiver. Next. देखो बेटा, how many times? How many times बेटा? So many times. 18, 19, 21, 13, 11, 2. है ना? What are the various modes of discharge of a contract? Beta, before earlier this is part of the CA Inter law also, Contract Act in the old syllabus. है ना? You may get the doubt why it is in 2013, how it will come 2011, how it will come in 2013, 11 it is part of CA Inter. है ना? So that means it's CA Inter question. By performance, by mutual agreement, by operation of the law, by impossibility, exceptions to supervening impossibility, by lapse of the time, by breach of contract. Same question beta, same question. What is supervening impossibility and exceptions to supervening impossibility? Exceptions to supervening impossibility. Right question. 2004 में आया बेटा में Mr. Akhilesh entered into agreement with Shekhar to deliver 5,000 bags to be manufactured in his factory. The bags could not be manufactured because of the strike by the workers. Akhilesh fails to supply the bags to Shekhar. Decide whether Akhilesh is exempted from his liability. No. Exceptions to supervening impossibility. Contract will not be discharged due to difficulty in performance, commercial impossibility, default by third party, strikes, lockouts. Related to due to strike by workers. Contract will not be discharged. Then it's our headache. But the same examples we discussed in the regular class. Every example 4 marks. What are the instances for discharge of by operation of law? Death, insolvency, insanity. And beta. Right question. What is meant by supervening impossibility, subsequent impossibility, and when supervening impossibility will arise? Right question. May 2007 है बेटा. Mr. Ramaswamy of Chennai placed an order with Mr. Shah of Ahmedabad for supply of urud dal. Which dal? Urud dal. Urud dal on 10/11/2006 at a contracted price of the 40 per kg. The order was for supply of the 10 tons within the month's time before 9/12/2006. Before that date, we have to supply the 10 tons of the urud dal, each kg 40. On 4/12/6, Mr. Shah wrote a letter to Ramaswamy stating that the price of the urud dal was skyrocketing to 50 rupees. Actually, agreed price is 40. Then seller said, sorry sir, so price increased to 50 and he could not able to supply the dal at a original price. The price of the urud dal rose to 53. Later, advise the Ramaswamy whether contract is discharged because of the commercial impossibility. Exception, commercial impossibility. Contract will not be discharged. But what is the contract price actually? 40. What is right price right now? 53. So if you are unable to supply, how much loss I will get? 13 rupees into 10 quintals. 10 quintals means maybe quintal is equal to 100. It's equal to 1000 kgs. Actually, 10 quintals means. Then beta. So how much we can claim from that guy? 13,000 rupees from the seller. Contract will not be discharged due to increase in the price. In the place of the urud dal, we discussed the tables. Carpenter. Then are you able to understand the questions? हो गए क्वेश्चंस भी हो गए. लास्ट 2 क्वेश्चंस बेटा. हाँ पढ़ेंगे बेटा. इतना बड़ा क्वेश्चन अराउंड 2025 2024 क्वेश्चन बेटा. Recently added, I forgot to add the year. Around 6 marks because 3 questions are there here, sub questions. 3 marks or 6 marks. Generally 2 marks or 1 mark. Situation based on situation. सुनो बच्चों, ये 24-25 क्वेश्चन है बेटा. See, on 20th September, X agreed to sell to Y 10 tons of particular chemical to be manufactured in his factory at the rate of 8,000 per ton to be delivered by 20th October. So here X is the seller, Y is the buyer. So we have to sell the chemical. Each ton ante beta 8,000 per ton. We should supply by the 20th. Contract is entered on the 20th September. We should supply it by the 20th October. We should supply. Still now clear? Calculate the amount of damages that could be recovered from Y, from X in the alternative case. Actually, this is related to next chapter, but a breach of contract question. Discuss करेंगे. The chemical could not be manufactured because of strike by workers. And X fails to supply the said chemical on 20th October when the price is 12,000. But what is the agreed price? 8,000. What is the price today? So how much he can claim? Into 10 tons. Each ton 8,000. Yes sir, no sir. So how much he can claim? 40k. 2 marks. It is question related to ordinary damages, but actually it will be covered in next chapter. Ordinary damage come strike. On 1st October, X informed Y that he was not going to supply the goods since the price of chemical rose to 10,000 per ton on 1st October. The price of the chemical further rose to 12,000 on 20th October. Why decided to resign the contract? Same. 8,000 minus 12,000, 4,000 into 10 tons. Why decided to? On 1st October, what is the price bid? What is 1st October? 10,000. So how much he can claim? 2,000 into 10 tons, because he is deciding on the 1st October itself. 2 marks. Last question beta. On 1st October, Mr. X informed Y that he was not going to supply the goods since the price of the chemical rose to 10,000 per ton on 1st October. The price of the chemical further rose to 12,000 on 20th October. Y decided not to resign the contract on 1st October, waited till the 20th October. On 19th October, the entire chemical factory was destroyed by fire without the fault of either party. Contract will become void. Can I claim damages? No. Supervening impossibility, I can't claim. Actually, this is also related to next chapter only. Somewhere it will come. I will explain when it comes. Then it is exception to, this question is exception to anticipatory breach of contract. Exception to anticipatory breach of contract. Then better last question. 21 December 3 marks के लिए पूछा बेटा. J contracts to take in cargo for Y at a foreign port. J's government afterwards declares the war against the country in which port is situated. Therefore, the contract could not be fulfilled. Because of the war, we are unable to go to that country. K wants to file a suit against J, examine the validity. Contract will become void due to supervening impossibility. Then done with the scanner. So we'll start next chapter in the next class. Have a great time. Enjoy the day. Prepare well. SG signing off.